opportunity to tell this truth. And I asked him, when did you first get on your phone? When did you first make a phone call? He said, only outside, 4 times. I gave him the opportunity to rethink about it, to use his brain to say, yeah, I even went so far as to allude to a video being out there. I said, so if there's a recording of you on the phone in the restaurant, and he said, no, phone call outside. First time I made the phone call. And then on the stand, when I questioned him about that, you heard what he said. So I think taken together, the inconsistencies of the Miss Fisher, the inconsistent statements of Officer Wilson, the videos that we have, it rises way more than reasonable doubt in this case. What he did do in the restaurant, by the things that he said in the restaurant when Miss Fisher was present with the little girl, did not rise to the level of disorderly conduct. It was not seriously disruptive. And we know that because nobody else in the restaurant was disturbed by it. Now, the video shows that Miss Fisher was clearly annoyed. That's what it shows. Very annoyed. And that's normal, right? It's normal to be annoyed when someone's taking a video of them that they don't know. But it's not seriously disruptive. And because in this day and age, everybody has their phone. Everyone's taking videos out in public. This isn't a public place. What Mr. Brown did was not illegal. Nothing he did was illegal that day. What he said in the restaurant that Miss Fisher could have overheard, there's a very good chance she overheard what he was saying into his phone. He does have a loud booming voice, but it wasn't seriously disruptive. No one else was disturbed by it. She was annoyed by it. Being annoyed is different than being the victim of seriously disruptive behavior. And as far as the contributing to the delinquency of a minor, now, we don't know if the child was upset when she was in Miss Fisher's car or not. I don't know, maybe she was. But in the restaurant, she wasn't upset. No one heard her cry. You don't hear her cry on the video. And again, Mr. Brown didn't approach him, didn't hoover his 6'8" frame, was not looming over the little girl. Didn't happen. So we ask that you rule that on every charge not guilty.
Thank you. Anything else, Mr.
Yes, Judge. Judge, I don't know if Mr. Brown would describe his conversation today outside with counsel as yelling and screaming, but certainly it caused everyone in the courtroom to turn and sort of wonder what was going on. That through a steel door and a glass window there. He's loud. So yelling and screaming, particularly loud. Call it what you want. Certainly from Ms. Fisher's perspective, she testified that it was disturbing to her that Kendall was clutching at her, trying to climb up with her arm. As far as approaching them, we heard from the defense's own witness, Mr. Polanyi, that Mr. Brown got up and walked over there. This is not a case about Mr. Brown filming Tucson police car. He wants to film a Tucson Police Department car. He can do that all day long. He wants to film the officers behind the car. Great, knock yourself out. That's not what this case is about. This case is about Ms. Fisher and Kendall Succo. And what do we know? We know that he knows that's their vehicle. We see in the video that he's right there in the parking lot. The defense counsel makes a big to-do about inconsistencies in statement. What do we have that's consistent? Mark Brown follows him out of the restaurant. He knows which vehicle is Brenda Fisher's because he films it. He's in the parking lot. They lose track of exactly where he is. So he goes, starts walk back to the restaurant, and then he reconnects and heads towards Officer Wilson's car. That's consistent, Judge. He's out there in the parking lot. State would agree, it's not a long period of time, but this is him wandering around the parking lot, trying to get a rise, trying to bait Officer Wilson. And Judge, we know immediately after that contact with Ms. Fisher, Officer Wilson confronts him about it. Stop filming my family. Yeah, then get another job, buddy. He knows what he's doing, he knows what he's done, he doesn't want the court to see what he's done, that's why we have only the video clips and not the entire video of the sequence. So they would ask that he be found guilty of all the charges.
Sure, Franklin, I think you mentioned at one point that after we saw and see the video zoom in on Ms. Fisher's vehicle, that later on in that clip, there was also, use that term, later on in that footage, there was also another time when the vehicle was focused on?
Yeah, on the entire clip, it pans back.
Okay. Right, the court's going to consider all the evidence and take the matter under deliberation.
Make sure.
I want to make sure I've got all the videos. I want to ask counsel a question, because this comes up more and more on these cases where it turns out there exists or existed video footage that answers all the questions that have been raised by the counsel. In this case, about really Mr. Brown's movements in and around the restaurant. If the parties agree to submit the surveillance video from the restaurant inside and out, I'm imagining that both sides want the court to view that because it would support their side.
There's no objection, Judge, we can require that.
We've happened before where the parties agree to have the court submit that video and consider it, and happy to do that if that video exists. Does either side know whether the video still has been retained?
Your Honor, I talked to the owner and the manager about this. Apparently, Mr. Brown, before he had the public defender as an attorney, he asked them about the video, and the owner actually reviewed the video and didn't see anything. And then, that's, I'm sorry, I shouldn't say that, but he did review the video, and then when I was retained and talked to the manager, I did question him about the video surveillance. He said, oh, it's gone, we tape over, but it was looked at. That's where I first found out that Mr. Brown had approached them for it. So as far as I know, it no longer exists. They tape over it apparently.
And Judge, of course, I object to all the hearsay.
Yes,
as far as
and
the court.
And that's just, I'm taking it for only whether or not the item exists, not for,
Right.
not for anything else.
Thank you.
I'll make sure I've got all the
Thank you.
videos, exhibits, and this is hopefully playable on.
the photos?
I've got,
Okay.
make sure I've got them all. Mr. Franklin, are you content that the video no longer exists?
If it exists, Judge, I was just talking to Officer Wilson about having another officer go see if they could acquire it. Certainly I would not object to its admission.
I would not either. If the police department, one of their investigators could try to get it, that, we would welcome that.
Or Walgreens.
Or the Walgreens,
No
I
objection
guess.
there either, Judge.
We would have no objection to that. We would welcome that. Maybe the police would have better luck.
Great. So what I'll do is, I will, we're not gonna have an answer today, I'm guessing.
Probably not. You
Oh.
gonna ask the police to get it?
Usually, any type of video request, the manager from Walgreens or whoever is in charge of all their IT department is gonna take a few days, if not a week, to look that far back if they even have it.
It may be that there's nothing, and the court will decide based on what the court has.
Yeah, because I didn't approach Walgreens, so maybe there's something at Walgreens.
And the bottom line, ladies and gentlemen, is that Mr. Brown's movements around that area and the sequence of events is obviously pretty important. Because if there's footage of Mr. Brown, and there's no secret to what I'm thinking, I'm not trying to hide anything from you folks. If the video, if the court believes that Mr. Brown intentionally zoomed in on that vehicle more than once, then that's at least circumstantial evidence that he was aware of whose vehicle that was, and that there may have been some interaction described earlier. If it's clearly coincidental, and there was no prior interaction, then the court should consider that as well. I think if there is video of Mr. Brown's movements outside, probably support, whichever argument it supports. So the court is very interested in seeing that video if it exists. And I appreciate that the parties have rested, but if there's obviously an agreement, Mr. Brown, that the parties can submit additional evidence to the court, then the court can still allow the parties to reopen the case and do so, and if necessary, re-argue the additional evidence. I'll give you a chance to do that. What I'm going to do in the interim is I'm going to schedule just a review hearing in the short term to determine whether or not this footage exists. I
Okay.
realize there may be some additional time to actually get it,
Uh-huh.
if it does exist, whether it's Walgreens or any other local businesses in the area. But I'd like to first know whether the video exists, because if it doesn't, then the court can proceed with the review of the evidence and deliberation. So, let's see, what date here? I know the officer said it usually takes a few days to determine whether or not there's a video.
I told him to contact someone who's on duty today and make it top priority.
So if I set something, even just a short review hearing at the end of even next week, is that enough time for, at least to get an answer as to whether or not we need more time?
We should.
Thursday or Friday of next week?
I'm good with either day.
Either one works for me, Judge.
Even EH on Friday, next Friday?
I don't know.
Sure.
So I could do Friday morning at 8:30 or even 1:30?
8:30's fine.
Works for me, Judge. Yeah,
Is that-
sure.
And you don't need to be here for that. Can I waive Mr. Brown's appearance for that? It's just to see where we're at with that Walgreens. You don't need to come. Nothing. 2 o'clock? Okay.
And if counsel, if you both discover that he does or doesn't exist in advance, and you can let the court know that you need more time, I can move that date in advance.
Okay.
Thank you, Judge.
All right, Mr. Brown, come up and get your cards.
And Mary Ann, C that you used is the same clip that you provided me earlier, right?
Yeah, it's just on the 2.
Right, but you didn't.
I didn't do anything to it other than put them on 2.
Okay.
Exact same that you got. Okay, so yeah, we can waive your appearance on that. May we be excused, Your Honor?